Hello, everybody. Yesterday, during my 16th lecture series, I've already mentioned that regarding the contract law, that is the contract law part one series I've discussed with all of us, all of you. So, this is very important to understand that today I'll be delivering a lecture on a session on contract law or the contract part 2 the series. Now this is very important. I've already mentioned in my previous lecture series that why contract is very important, what are the various factors which are involved in the contract, like for meeting of minds, that's the consent. Then we have got consideration, that is that how much money or the value we are going to pay. It can be in cash or it may be in kind. So, and also that whether entering into a contract and what is the contracting, what is the rights and obligation of the parties who are entering into contracts. So, those are the basic fundamentals. So, before understanding any contract or contract law, we in India we have got Indian Contract Act 1872. So this is an important session for not only for the law students, or maybe it will be an add-on for the law academicians or the scholars who are working in the area of PhD. That what does the contract law actually means in India, and how and which act or the enactment actually governs the contract law in India. So, in the terms of Indian context, it is very important to understand also that the Indian Contract Act 1872 was a it's a very old act, and very important to say that it was in the British era. It means it is in the pre-independent period, and it was enacted in the 1872 by the Imperial Legislative Council at that time. We have got. So right now we all know that the laws are actually enacted by the Parliament and the state legislature. If it is a state, then it is a state legislature, the jurisdiction within the state itself. And if it is central law which has been passed, for example, Income Tax Act, in my previous lecture series I have spoken about. So it is being passed by the Parliament, and it has got the jurisdiction throughout the India. So this Indian Contract Act has been passed in the year 1872, and actually it governs the law of contract in India, and it is the principal legislation regulating the contract law in the country, and it is still governing. Now, actually, it is applicable to all the states of India, and it outlines the circumstances under which the promises. Promise is what? The promise, I will explain what do you mean by promise, what do you mean by offer, and what do you mean by acceptance. Actually, it is a kind of a consideration in which the promises made by the parties to the contract become legally binding. It means I have already spoken about that whether it is legally enforceable or not. So, when you are making a promise to the other party, and if the promise comes into the picture of the contract, whether it is being legally enforceable, legally binding in nature. Section 2H of the Act, that is the Indian Contract Act 1872, defines a contract as an agreement that is enforceable by law. So you need to understand that when the Act was developed in the 1872, the general principles of the law of contract containing the sections 1 to section 75, and there are 6 chapters. Apart from that, there is also Sale of Goods Act and Partnership Act along with the Contract Act. Those who are studying in the undergraduate law or postgraduate law, or anyone studying BCom or MCom, or anyone dealing with any kind of professional charter accountancy or cost accountancy or company secretary, they have to know the contract law. Contract is very important for professionals as well as the legal advisors. But apart from them, there are many individuals and businesses who need to also understand what is a contract. How do you enter into a contract? What is the significance of an agreement? If you go through the bare text of the contract law, the Contract Act, if it can be downloaded from the website, and you can go through in your phone, in your tab, or in your computer, and you go through the text of the contract law, and there are many illustrations also given, and it is beautifully explained also in the bare act, and it will help the businesses to understand that how to enter into an agreement. What do you mean by the promise? What do you mean by consideration? Actually, part 1 of the Contract Act, actually it is divided into 2 parts. So part 1 actually contains the general principles of law of contract. It is chapter 1 to section 1 to 75, chapter 1 to 6. And part 2 actually deals with 3 categories: chapter 8, chapter 9, and chapter 10, special kind of contract. Number one is a contract of indemnity and guarantee. Number two is a contract of bailment and pledge, and another one is contract of agency. So we all know how the agency functions. We all know the concept of principal and agent. In businesses, it actually happens. For example, you have got a principal here in Kolkata, and you have got an agent in Delhi. So if you are supplying textiles or any other material from Kolkata to Delhi, the principal is sending the goods to the agent in Delhi. So there is a transfer of goods and services from one place to another place, and there must be a contract of agency. So that kind of contract actually governed by this Indian Contract Act. There are very important definitions to understand in the Indian Contract Act. Number one is the offer. So what is the offer? This is the basic fundamentals of entering into the contract law. Offer is what? Offer is something where it relates to the promise, and that is dependent on a certain act or a promise or a forbearance given in exchange for the initial promise. It means, when you're in simple terms, it means, these are legal definition I'm talking about. In simple terms, it means, for example, if I'm making any offer to X, then obviously the offer should come from me, and it should be based on such a certain act or promise, or maybe forbearance also. It means that some offer has come to me also, and I'm making a counter offer. This is also an offer, forbearance of the act. So this the to actually dependent on a certain act and a promise. Next is the concept of acceptance, the whether the offer is going to be accepted. So when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Now, what is a proposal? The proposal is something, for example, if I am making a proposal or an offer to purchase my property X. So X will be the buyer of the property, I am the seller of the property, I am the owner of the property. I am making an offer to him or her that you purchase this property. So this is offer and acceptance, and subsequently X will accept to purchase the property. So this is an acceptance. Now slowly we are entering into the contract. Finally, it will be on the paper and agreement. We all know deed of conveyance, and this is the basic fundamentals how it operates. And what is a promise? Promise is this: I will obviously hand over the property to you in exchange of the consideration that you pay to me. On the other side, X will give the promise to me that I will pay you the property. I will pay the price of the property, and subsequently you hand over the property to me. So this is also promise involved. So promise, the definition which is given, that is a proposal when accepted becomes a promise. So ultimately, if there is a promise between me and X, it means that when the proposal is accepted, when the offer is accepted, then it becomes a promise. In simple words, when offer is accepted, it is called a promise. Now, what do you know by the definition promise, promisor and promisee? It means that when the proposal is accepted, the person who is making the proposal is called the promisor. It means I am the promisor. I am making the proposal to whom? To the promisee who is accepting the offer. So that is the promisee. Now, what is the consideration? Section 2D of the Indian Contract Act talks about the consideration. Consideration means that when at the desire of the promisor, the promisee or any other person has done or abstain from doing or does or abstain from doing or promises to do, to abstain from doing something, or is called a consideration for the promise. Now, price which has been paid by one party to the promise of the other, in technical word, quid pro quo, something in return. So we always heard the words in law, it's called quid pro quo. It means something in return. It's a Latin maxim. It's a maxim, legal maxim word. And this is the origin of this word, that consideration. It means that I am handing over the property to the X. In lieu of that, you are paying the price of the property. There is a consideration. Quid pro quo means something in return. Now here comes the very important thing out of the offer and agreement. Is the offer and the consideration and acceptance is the agreement. The contract and agreement. So every promise and every set of promises forming the consideration for each other. It is called the agreement. All the promises will be laid down. All the terms and conditions will be given, and it will come into a single one picture called agreement. So So you have understood till now. We will go a little bit slow also at the same time. For that, each and everyone should understand the concept of contract, because it is very, very important for all of us to know that in day-to-day life, I mentioned in my first lecture series of the contract law, that in day-to-day life of every individual, we are having a contract with each other. Whether it can be with the individual, it can be with a company, or in any mode also. So not only understanding but also interpreting the legal terms and conditions. I would like to advise one thing. I should not give advice because I'm keeping this thing as a kind of a session interaction. But obviously, I'll give a put advice for each and everyone, that before entering into a contract or signing any agreement, please kindly read the terms and condition. Because see, in legal language, there might be some legal languages, there might be some difficulties of understanding or interpreting the legal languages. For those, there are professional lawyers and the legal advocates, and they are going to help you. But initially, you go through those terms and conditions. Please read. Some of the terms and conditions are in very lucid and simple languages. Please read. Even if it's small, ask them to provide a proper terms and condition, because when you are entering into the contract, it is the responsibility of the other party who is providing the terms and condition to provide in a simple, lucid and transparent language. So please read. Don't neglect the terms and condition of the agreement or the promise that we are entering into, because that is the most important fundamental of the contract. Because if there is any difficulty or breach at a future point of time, then it might go into the court of law. And because of signing it without reading the part of that, you might be in a loop, you might be trapped, you might be in a difficulty, and you might lose the case also at some point of time. You might be asking for the damages. It happens. The other party will now seek the damage from you, in spite of the fact that all the fault lies with him or her, or the entity itself. So I will continue with this contract law series for in future course also. Tomorrow also I will come up with the contract act, the contract law part 2, the part 3. Today I have discussed about part 2, then I will come with part 3 and part 4. It will continue. I'm planning to do a longer series with this one, because this is very important concept, or the thing that we need to understand in our day-to-day life. Thank you very much for watching.